Hi, this is Richard Rellis with columnist Robert Robb outside the Songbird here in downtown Phoenix. We have to pay a new fee when we register our cars. It's 32 bucks. The reasons why are complicated, but I figure it might be best if I try to explain it back to you and you steer me in the right direction where I get it wrong.
Okay.
Years ago, voters said if there was going to be some new tax, we needed to,
or new fee.
New fee. It needed to be approved by the legislature by a 2/3 majority.
Correct.
Yet we're going to be paying this $32 fee increase.
Even though it was not passed by a 2/3 majority.
So there was a court case that was done when we were expanding Medicare, where hospitals would pay a fee, and the Supreme Court ruled that was okay somehow.
Even though that Medicaid assessment was not approved by a 2/3 vote either. They came up with a very innovative theory. The theory was that if the legislature authorized a new administrative fee and set limits on it, that's what required a 2/3 vote.
Because it's the legislature acting. If they say there's no restrictions and the director of the administration or the department sets the fee, then they're just ceding their power to that department?
It was not that well thought out.
All right.
It simply said, based upon how they constructed the exemptions to the 2/3 requirement, that if the legislature simply said, set a new fee, do whatever you want with it, that's okay, then paradoxically, giving unbridled authority in terms of setting the fee required fewer votes from the legislature than actually setting limits.
And this was done for Medicaid, this was done for healthcare expansion, which was kind of popular at the time. I mean, your column suggests that courts didn't want to be the ones to take away healthcare. I mean, the motive is not clear in the ruling, right? But
no, and the court would never admit it.
Right.
But the consequences of holding that the Medicaid assessment was unconstitutionally approved would have been to put at risk the health care of hundreds of thousands of Arizonans. The decision was authored by Chief Justice Scott Bales.
Which is why you've given it the name, the Bales loophole.
The Bales loophole. And he said, not to worry, nothing absurd will occur because of this self-evidently absurd distinction.
So now
the very next session, the legislature marches through this public safety fee by giving the director of the Department of Transportation unbridled, unlimited authority to set a fee to pay for the highway patrol.
And I remember, I mean, when I was at the session this year, this bill came about. It seemed to be dead in the water, but at around the time that Governor Ducey was looking for new funds to pay for the teacher pay raises, this bill suddenly gets revived, and the Department of Public Safety is now funded by what we thought was an $18 fee that now is going to be nearly double, 32 bucks instead. You're calling for it to be repealed.
I am, and you do have some legislative buyer's remorse because this is much higher than they anticipated. I think you can assume that there's going to be a revolt among car owners, and it was in, I think, underhanded attempt to get around Proposition 108. It's terrible governance. I mean, here you have a director setting a fee to pay for an activity, patrolling our highways, for which the legislature has never approved a budget, and takes place in an entirely different agency.
Right, he doesn't oversee that.
There can be an honest debate about how do we pay for the highway patrol, whether it should be general funds, whether it should be the Highway User Revenue Fund, whether it should be a fee. But don't wash your hands of responsibility because the court created this creative loophole. And the state's rolling in dough right now, so let's repeal the fee, start over, have the honest debate, rather than attempting to do it in such an underhanded way.
And in a way that's showing up at your renewal fees if your tags are due beginning of this year.